Well, thank you all for joining us today. We are very excited about the panel that we've assembled to talk about preservation and specifically around the concepts of proportionality as it applies to preservation. I would like to take this opportunity to introduce our panel, and then I'll turn it over to Ron as our moderator. So, our panel today, first is Honorable James Francis, and of course their full bio is in the handout, so I won't go through all the details, but Judge Francis is a U.S. Magistrate Judge, Southern District of New York since October of 1985, served as Chief Magistrate Judge, graduate of Yale College, serves as an adjunct professor at Fordham University School of Law, and frequently lectures on a variety of topics, including employment discrimination and electronic discovery. Second panelist, representing, and as you might have guessed from the course materials, we've tried to bring in different perspectives. So representing inside counsel, Lynn Dummett is the Senior Vice President and Senior Counsel at Allianz Global Investors. And Lynn joined Allianz in June of 2001 and is currently responsible, as she says, for multiple mandates, including management of AGI's Records and Information Management Program. She manages the litigation, and especially around electronic discovery, and oversees their privacy program. Lynn's background also includes both as a partner in Cynthia Austin, LLP, senior in-house attorney litigation at AT&T, and served as an assistant U.S. attorney for the District of New Jersey. Third panelist, representing the plaintiff side, Bill Butterfield is a partner at Hausfeld, LLP. And Bill concentrates on antitrust litigation and is internationally recognized authority on electronic discovery, among other topics. A varied career, including testifying in front of the U.S. Judicial Conference Rules Committees, a member of Sedona Conference, so very involved in these topics today. The defendant side, Robert Owen is a partner at Sutherland, Asbill, and Brennan. Bob is also a nationally recognized advisor to financial services, energy, and technology companies. He has, he's currently a partner, has had a background including a boutique litigation firm, Owens & Davis, which he co-founded. He serves as a member of the editorial advisory board of Law Technology News, also a member of the Sedona Conference, and a varied career. And then finally, our moderator for today, Honorable Judge, former Judge Ron Hedges. He's the principal of Ronald J. Hedges, LLC, extensive experience in electronic discovery, serves as a special master, formerly U.S. Magistrate Judge, United States District Court of the District of New Jersey, serves as an adjunct professor at Georgetown, and is currently at Counsel. With that, I'll turn it over to Ron. Our agenda today really focuses on three key topics. We want to talk about how we go about addressing the challenges of preservation, especially in context of pre-litigation. Provide a very brief update on what's being discussed in terms of proposed rules changes to federal rules. And then finally, and perhaps most importantly, focus on ways that we as an audience, things that we can take away to be better prepared to mitigate the cost and risk associated with data preservation. With that, I'll turn it over to Ron.
Good morning, folks. If you have any questions, we're a small audience, so just stick your hand up and we'll interrupt and see what we can talk about. Lynn, I'm going to start with you today because you're in-house. At some point, you may be thinking about litigation, or litigation is thinking about you, and you know that's going to happen. And we know whatever you do now is going to be judged by somebody 2 years from now, or 3. Judged by Judge Francis, someone else. So let's start from your perspective, even before you might call Bob or get into court. How do you start deciding what you're going to keep in the context of litigation that you anticipate happening?
Well, one of the first things that I do, and since I've joined Allianz, is try to get a better understanding of the types of data that we have in-house and data map to understand the expanse of data, whether it's electronic or hard copy data that might be relevant. The next thing I do, which is typical of what my practice has been for years, whether it was in-house or outside, is try to understand who the relevant parties are within the company that might have potentially responsive information. And that is focused on connecting with the people in the various business groups that might be relevant to the dispute and determine what it is that they may have, what their involvement is. And then more importantly, I also, whether it's pre-litigation or we've actually been served with a complaint or some type of regulatory information request, issue a litigation hold. That decision, for me at least, turns, if it's pre-litigation, on the likelihood that there will be litigation, what the issues are that are presented. But in that context, I spend a lot of time just trying to identify information, once again, whether it's electronic or hard copy, and sit down with people, have conversations, and try to develop as much information as I can to understand the types of information that we have in-house. And it's not always a perfect world, because I think, as we've been discussing, a lot of companies today are in a state where we're keeping everything. We're not getting rid of information. So therefore, it makes it more challenging, in my view, to really understand what you have that's available.
Bob, the phone rings. Lynn's on the phone. She wants you to come see her at her office tomorrow to talk about this litigation.
And I'm smiling.
Of course. And beyond that, Lynn talked about a data map. What do you look for when you're going into a new client that you really haven't worked with before and you want to get a handle on the information? At the same time, Lynn or her equivalent is saying, by the way, Bob, we want to keep our costs down here. What do we do?
Well, one thing you do is you rely a lot on the in-house people. They know their company, they know their people, they know their systems. Whether or not they have a data map, they're your first point of contact, and you rely on them. And I think the most effective litigation teams work together with the in-house people, not as some separate island of superiority. But, you know, in the normal case, preservation pre-litigation is very ad hoc, and it depends on what you think the allegations might be, because you don't have a complaint yet. What you think the other side might press you on, because you don't really have an adversary yet either in many cases. And what you think the judge may or may not want you to do, because pre-litigation you don't have a judge either. It is a very challenging environment, pre-filing, and you know, I think you have to be quick, you have to be alert, you have to be diligent, and you have to act in good faith. Beyond that, I don't think there are any rules that I could describe to you or to the audience.
Let me supplant Hedges for a minute and ask some questions here, because there are a couple things that come to mind.
But you realize they can't get to you before the complaint's filed, right?
No, that's
Okay, go ahead.
When you're talking about the likelihood of the litigation, I'd be interested to hear what factors you consider, and particularly whether you trade that likelihood off against the potential value of the litigation. That is, are you concerned only with is this 90% likely to come to court or 50% likely to come to court or whatever? Or are you also thinking about, well, it's only 50% likely to come to court, but it's a multi-million-dollar case if it does, as opposed to, well, it's 90% likely to come to court, but it's only a $10,000 case. Does that come into play in your analysis, whether or not to start preserving and how much to preserve?
I have to say, from my perspective, I tend to be conservative. So I don't necessarily look at dollar value of case versus likelihood of commencement. My view is that if there is a risk of litigation that I think is reasonable, whether it's associated with, an alleged breach of contract claim, or I know that an employee is departing who may not be leaving under particularly great circumstances and who may not have indicated that they're going to commence a suit, but I have a sense that there might be some issues there. To me, it's irrelevant in terms of the dollar value of the case or the likelihood of this costing X amount if we take these steps now. My view is I need to be conservative. I need to act in good faith, and if I have a reasonable belief that there is a potential for litigation, I am going to take steps to lock down what it is that I think is most relevant at the time. And as Bob says, sometimes that's difficult to assess without a complaint or without some type of demand letter because of the fact that I'm not sure what the totality of the allegations are going to be. So really, in the early stages, I'm operating in good faith and trying to make the best assessment that I can as to what is likely to be the most relevant, and I try to get that locked down.
For my part, that's very consistent with my experience. One of the things, Bill and I were both at the mini conference in Dallas last September, and one of the things that came out very clearly at that conference was that the people in-house don't want to take risks with their company's brand. They don't want to take risks with their own careers. And so inevitably, they over-preserve. This whole panel is about preservation and proportionality, but if there is a risk of a sanctions order against my company, and I'm now imagining myself in-house, or against my client Lynn, I'm not going to take any chances. I don't have a basis for making proportional decisions. I don't have an adversary to talk to. I don't have a judge to bless it. And so it's like buying insurance. Do you not buy insurance on your house because there's less than a 1% chance of the house burning down? You take those steps. And so we have a system that all of the stars line up in favor of over-preservation.
Is a corollary to that once you've decided that there is a trigger, then your preservation is full bore. That is, you don't calibrate your preservation depending upon the likelihood of litigation. You simply decide in a binary fashion whether it's likely or not, and if it's likely, then you institute your litigation hold, et cetera, et cetera.
Except in the most extremely small case, I think that's right.
We have a question from the audience, but Bill, let me ask one question first. We always talk about preservation from the defendant's side. That always seems to be where people are concerned about. But how about a plaintiff's side? When do you reasonably anticipate the litigation? When you say, client, I'm going to represent you, or someone's come in and talked to you? What steps do you take when you decide to preserve them?
Well, it definitely is not, there's a little more guidance for the plaintiffs about when to institute preservation than there is for defendants in many cases. But oftentimes we have parties who come to us and say, well, I think I have a claim and I want you to take a look at this. And we take a look at it and do due diligence, and we say, we don't think you have a claim. We don't, thanks for coming, but go somewhere else. So I think there's a point in the process where we're investigating and we conclude, we think that a claim may lie. We're going to start looking at drafting a complaint. At that point, obviously we reasonably anticipate that we're going to litigate. It's interesting, a lot of plaintiffs' counsel forget that they also have an obligation to preserve, just like defendants. And if you look at the jurisprudence on spoliation sanctions, a lot of those cases come from plaintiffs screwing up, some of the biggest cases. So we have obligations just as defendants do. It's a little easier to manage because we have, at that point, we sort of know when we reasonably anticipate. We know we have a better idea probably of who's going to be involved on the plaintiff side, what type of information is going to be involved, and what needs to be done to preserve that information.
Now, let's take the question.
I was wondering, we just had a question from Judge Francis' question earlier, and you talk about lockdown and when litigation is likely and what steps you take to comply. And I was wondering if I guess all of you could talk to the degree to which you would comply. I guess so. When an inspection is just issued, litigation hold to everybody that you think covers the custodians of potentially relevant information. And then there's actually going out and following up, getting the BlackBerries, getting the emails and the archives, and storing that until you don't need to one at the other inspection. I was wondering, so the question, Judge Francis' question was about, well, does it matter? Does the size of the litigation matter? And how does that matter? How long, or will you just your response sounded like that. Doesn't matter. It doesn't matter the size. You're conservative, and you'll just go out and get all the information so it's preserved, as opposed to just tell everybody that you need to preserve.
Well, I think it depends on the circumstance. And once again, in my mind, there's no sort of hard and fast rule in terms of whether you issue a litigation rule which says I'll be in contact with you shortly and we'll discuss collecting information versus actively at that point going and collecting the information. And a lot of it has to do with the type of case, the issues involved. If it is a smaller case where the exposure is not great or something that's going to settle very quickly, obviously I'll always issue a litigation hold. I may not go out immediately and collect every single piece of paper. I might do a more targeted focus of the relevant custodians that I know that have the information that's targeted to facilitate my resolving that case sooner rather than later. But I will always make sure that regardless of who the custodians are, that they are at least on notice that they need to preserve. There are other types of cases where I perceive, especially in a heavily regulatory environment, where we may take more affirmative active steps immediately to go and image hard drives and things of that nature, depending on the allegations of the case, whether we're dealing with the SEC or some other governmental entity. So it depends on the matter. But I think the minimum always, in my view, is issuing the preservation notice. And we have a system in place where it's automated now, and people have to respond. We track what they're doing. They understand what they need to do to lock things down. So in our environment, it's a little bit different as well because we capture all email, so that makes things a lot easier in a regulated entity.
Were you required to keep email, or I am also too?
Yes,
for 3 years, right?
We are, well, it's longer,
Yeah.
for longer. So we already journal and archive that information.
Let me just ask this question when you want to go on and talk about something. Everyone talks about BYOD now, bring your own device. Everybody's got a device you probably use for work. Bob, you're counseling Lynn. What do you tell her other than to tell their employees they can't do anything else except on a mainframe in an office?
Well,
I'm going to ask Bill the same thing.
They're going to tell me that they need to do their business, and productivity trumps basically buying insurance. And so BYOD is very much a part of life. Here I have my iPhone. It's not firm issued, but it has firm email on it. The firm is taking some risks by making that available to me, no question about it. But you have to, in a sense, that's a proportional decision on their part because they're balancing risk and benefit.
And
they do it all the time.
on the home computer?
Same, you know, everybody does it. I mean, I carry my laptop every place. So in a sense, I'm always at the office. I don't work on my home machine on a VPN or Citrix or what have you. But, you know, productivity and the utility of these devices is what drives their dispersion and the explosion of data. No one's going to step in front of that train. I'm not going to tell Lynn that her people have to do all their work in the office. It's just, you can't.
So Lynn, how do you collect that? Let's say you've got some matter, you have 10 employees you need to collect information from. We know they work at their PCs, they have iPods, they have iPads, they have everything. What do you do to them? Say, gee, let me come on in, bring in your PC. I'll just go through it and I'll take the stuff I need and I'll give it back to you.
Well, I think the first place you start are, you know, with the policies and procedures you have internally. So, for example, if you're using a personal device, you know, we have policies and procedures around, if that's your personal device, you should not be doing business on it. We have company-issued devices which you can't, or you can use your personal device, and with applications and technology today, you can actually be linked to the company data, right? So in that context then, we have the ability to capture that data because there is technology out there that permits you to do that. There is, you know, the good application and et cetera, where a lot of companies use that to make sure that they can capture what your work-related material is. We have policies in place where if you're doing work at home, then you have to use an encrypted thumb drive, and you know, so that we try to make sure that we have access to the information that is business related. Obviously, there are employees that are going to go home and sit on their work, their personal desktop sometimes and do work at home. And from my perspective, if that's what you're doing, when you issue a litigation hold, it's very clear in our policies that if you have information at home, that has to be provided.
Bill, from your point of view, do you want to see things on people's home PCs or whatever in general matter? Is this a 30B6 question first and go from there?
I mean, I would love to walk into a 26F conference and have the other side say, the only place where anything relevant is on somebody's desktop. All right, that'd be an easy situation for me, but unfortunately that doesn't usually happen. So I'm trying to, and just the same as my colleagues, I'm trying to figure out in any lawsuit, okay, what type of information is likely to be relevant to the dispute, who created or received the information, where is it located, be it on some server somewhere or some desktop in the office or some laptop at home, and what is a reasonable way to A, preserve it, and B, collect it.
So one of the first things you want is Lynn's data map.
I want Lynn's data map, and I want to engage in a discussion with Lynn or her counsel, Bob. And I want to talk about those issues. But I do feel strongly that I need to be proportional. So just because the institution uses instant messages, if I don't think instant messages are going to be relevant to what I'm looking at, then I'm not going to go after them just because they're there. If I don't think, and this kind of analysis I think becomes more and more important because there are more and more types of information floating all over the place. There are Facebook messages, there are LinkedIn messages. So if I go whole hog and I say I want everything from everywhere, from everybody, I'm likely to, well, I'm not being reasonable, and I'm likely to get whacked when I go to see Judge Francis.
But are you going to say, I don't know that I want it yet, but you better preserve it?
I'm engaging that in that analysis. So if what I want is an open dialogue with Lynn and with Bob about what information is likely to be available and where is it, and then let's make some decisions about what to collect and produce now. Let's make some decisions about what not to collect now, but what to preserve in case we need it later. But that all has to be part of that dialogue. And I have been in cases where, I can remember one case where there were 400 preservation custodians from one defendant, and the defendant only produced for 30 custodians. But a year and a half into the litigation, we found out that one of the custodians for which they didn't produce was a very important player. This was the guy taking notes at the meetings we were in. So thank God, that the preservation umbrella was greater, and the other side was able to go back and collect that preserved information and produce it.
Dan,
But hold on, I'd like to ask Bill a question, and my question is this.
I'm having so much fun moderating.
Please stay out of the way.
Sign of a true leader.
Let's say that you and I have a conversation pre-litigation, and we come to some agreement about what needs to be, because we're talking about preservation. And I tell you, look, I really don't think that IMs are likely to have anything relevant, or voicemails, or what have you, and you say, okay. But then later in the case, it develops that there was some crucial information on IMs or voicemails. Can you assure me that you and people in your position will not use that fact to bring a spoliation motion against me, especially if their case is teetering on the merits and they really would like to gain some leverage at the settlement table? Because that's the problem that I face pre-litigation, talking to reasonable people like you, because the focus inevitably becomes what's missing as opposed to what you have. And that I think is really the nub of the problem.
Well, you wanted something in writing, I assume, at the
You
least.
would want a stipulation, and that would protect it. But I would want to engage in a pretty full conversation with you. Why don't you think IMs are, maybe you're going to say IMs were not archived, they were turned off.
Well, maybe
That's
I
an
say, I
easy
don't think,
answer.
in good faith, Bill, I don't think there's going to be anything relevant on IMs. And I believe it at the time, and you and I both believe it at the time, and we enter into a stipulation.
Yeah.
But it turns out that the witness comes along and says, oh my God, we knew the conspiracy in-house used the IM system to evade detection.
Yeah.
Are you going to sit back and say, well, we stipulated so it was all fine, or, and I'm not positing you, but I'm positing someone that litigates in New York all the time and makes their living in Special Term Part 1 downtown. That's the worry that I face.
Well, the first thing is you can't have a stipulation because nothing's been filed.
Well,
So you're signing a little contract between yourselves, right?
Yeah,
Isn't
normally,
that right?
those conversations usually, frankly, take place after litigation is commenced. I don't normally engage, I don't have, because it's just a matter of logistics. The other side doesn't even know who I am until my complaint gets served. So it's probably unlikely to happen, but and after the complaint gets served, there is going to be a stipulation that's going to go in, and it's a lot of, I've known you for years. I would know that you make that representation in good faith, and we've stipulated, and that's the end of it. I would want to engage in some due diligence before I buy off on your
Of course you
comment,
would.
and we're going to talk about maybe particular custodians, and I'm going to say, these three people were at the center of the conspiracy. I hear you, but let's just leave the right to get IMs if necessary for those three people.
So I have to preserve them.
So you have to preserve them.
Okay, well, Dan, let's go with you first. Then I have another question. I'm going to start with the judge.
When I hear about proportionality, it seems to me that proportionality is more critical for preservation than production, because you can always renegotiate production if you've preserved it. And it's really the proportionality, how much do I preserve? And so my question to the panel is, we're moving away architecturally from a highly distributed world where everyone has their documents on their own laptop to where we are more connected to each other, into the organization. And I see many more copies of the same file because of the way the organizations and the computers work. So how does the panel feel that preservation decisions are being made or will be made differently in the future as we rely more on cloud computing and network computing rather than distributed.
You're reading my mind, because I was just going to ask, starting with Lynn, I assume you have a website?
Yes.
I assume you have a Facebook page, the company? No? No Facebook pages for you? Okay. So let's assume we're with the company that does. Companies use social media all the time now, right? You use the web, maybe you don't use the cloud, but a lot of companies use cloud storage because it's perceived to save them money. And I think that's a perception more than anything else. Leave that one aside. Bob, how do you deal with that? How do you advise someone, let's say you've got multiple copies of things, or you've got a lot of things out in the cloud, your client? Number one, how do you lock that down? And then number two, how about Dan's comment that we've got 80 copies of something, they're identical other than some routing information. Do we need to keep all that?
It depends on your goal. If your goal is to be able to win every single spoliation accusation, yes. If your goal is to keep what's essential to the litigation, no. One of the features that Dan has pointed out about our world now is I think it's almost impossible, if not literally impossible, for a single user to successfully delete every single copy of a damaging email. They can never be sure they got every copy. They can delete it from their own inbox and double delete it, but the recipient got it, the CC people got it, the cloud got it, it's on some server someplace. And so this is one of the reasons why I think the very expensive, very intense emphasis on affirmative preservation steps is misguided. Because as opposed to when I started practicing in the 70s, you could go to the file room, pull out a single manila folder, throw it out, and that was it. You can't be sure now, if you're an ill-willed person, that you're going to get every copy. So I think our focus on saving every copy of every document, or even every email, every unique copy of an email is misguided and way over expensive compared to the benefits for the system, where we still have juries and witnesses and common sense and trial advocacy and judges in courtrooms. You know, there's never been a case in my lifetime where there was a perfect documentary record, and yet somehow we reached fundamentally just results in these civil litigations.
From the legal perspective, I don't think anybody contends that the preservation obligation extends to every copy of a document. You know, it's unique data that has to be preserved. I think the question comes down to one of cost and logistics. That is it going to be worth your while to try to pare down, to invest the transaction costs in paring down till you get to that one unique email? Is it worth your while trying to discard all the copies? You know, that's just a factual question, and I don't know how it comes out in any particular circumstance, but I don't think there's a legal obligation to hold on to more than one copy.
Bill,
And that's part of what I hear.
Let's go to Bill and we go to that. What do you think about getting every copy?
Well, I mean, I agree with what Judge Francis said. I mean, you're talking about a single copy of a document. But I'm reminded that we had dinner last night. We had a conversation, and part of the conversation was that, and part of the problem is that storage is becoming so cheap that there's less and less incentive to throw things away. We can store in the cloud, we can store everywhere, and at some point, you know, corporations saying, is it worth the money it takes to sort of follow a retention policy and get rid of documents as they are no longer needed for business, or should we just store everything forever? Now, I don't have an answer for that question, but as companies are less and less incentivized to engage in an active records management plan, retention plan, we're going to have this problem because we're going to have multiple copies. They're going to be all over the place. And query whether or not, you know, that's a corporate decision saying, rather than actively manage our information, we elect to save money by just storing it forevermore. When it comes time to preservation, I think there has to be consequences to that decision.
And then Lynn gets to go through everything that's been preserved forever to see if there's anything relevant.
Well, and what I was going to, in response to Bill and the point that Dan made as well, you know, what I also hear Dan saying is that you don't necessarily want 100 copies of the same email.
Of course.
No one wants that. So
No.
at the end of the day, I respectfully disagree to some extent with what you said, Bill, because I do think companies today get that they can't keep everything, and they don't want to keep everything, because it's not just, you know, to the extent that we perceive that storage cost is cheap, and we can just save everything forever. That may be on some levels, but the problem with that is that kind of model, you just can't keep everything forever and then protect yourself from the legal and other risks
There are
associated
consequences, yeah.
with keeping everything. So
It's
I
like-
think,
It's the downstream risk, it's not the cost of the media on which you're
Correct.
preserving.
Right.
because
It's
it's
the management
the
of the
management
data.
of the data, and then knowing when you are in a situation where you're in litigation, that you know where everything is. And if you're keeping things that, in accordance with a normal record retention management program, that you can roll off, consistent with your retention schedules, subject to there being any existing litigation holds, you're actually putting yourself in a better position, because you have a defensible process in place that says when you come along with your discovery request and we sit down and have our conversation, I can say to you that this data rolled off in accordance with my retention schedules on this date because there were no litigation holds, and pursuant to law and regulation, we could roll that off appropriately.
And that's how it should be done. I agree with you. I just worry that some companies who are paying less attention to that active records management process being sloppy and keeping records because it's cheap to keep records. And there are consequences to that. And maybe the short-term consequences are you save some money because you don't have to engage in the process of records management. But there are long-term consequences when it comes time to preservation.
Well, Lynn, who monitors and enforces your records retention schedule? Because one of the problems I've often heard is everyone doesn't, we have nice record retention schedules, but people don't follow them.
Well, that's...
Let me make it hypothetical.
That's okay. Let's make it hypothetical.
Let's make it hypothetical.
Well, let's say, for example, you know, in terms of the hypothetical scenario, in that world, we have a records manager, and part of her responsibility is to ensure that the various operating entities are managing their records in accordance with the records retention system.
And does she have white hair or gray
No,
hair?
not yet.
Okay. All right.
One of her colleagues does, but just happens to get it dyed frequently. But we you know, try to be mindful of whatever our regulatory requirements are, and also balance that against what our legal requirements are, because the regulatory requirements can, actually, those time periods can be less than what some legal requirements are for a kingdom. So, you know, I think in a perfect hypothetical world, you have an enterprise content management system which is automated, where we're dealing with the issues of creating records that have uniform taxonomies in place that are tied to record retention time periods.
Right, we're talking about auto classification, which
Correct.
is a big phrase going around at
Correct.
the MER conference.
And we make sure we're not keeping duplicates and triplicates of the same record, and we're tying our email to our electronic records, and we're managing to our retention schedules. That's the world, to me, that companies have to get to. I'm not saying, and that's something that takes time. It's not something that happens overnight, and it's not easy. But that's the state, I think, companies have to get past what Bill is talking about, in terms of the risk, because at the end of the day, from my perspective, if I don't have to hold on to something and I can, in accordance with a defensible record retention policy, dispose of it, and there are no legal holds that are preventing me from doing that, there are no issues, that's a better state for me to be in.
Let me just take a question to Dan. You had a question?
I'm going to abandon that one.
Okay. Dan?
No, but what did...
Oh, it's another question.
Before on the topic you guys are talking about now. What do you do with information? I guess this is more to in-house attorney. What do you do with information that it's archive files, back tapes, it's a compilation of a ton of information, electronic, and you don't really know what's on it. You know, it was made for disaster recovery purposes, or it's just a backup, and you know it's likely to have some. There's a chance that there's some relevant information on there. It's related to some litigation, but it's just a ton of stuff, and you really don't know what's on it. How do you deal with that?
Well, we could start internally with Lynn, and we'll ask Bob what his advice would be. How's that? Or should we do it the other way?
Well, I mean, that's a complicated question, because I think under the rules, the spirit of the rules is that it has to be theoretically readily accessible, right? You know, the concept of, you know, what's the burden if you have to restore?
To search for it and produce it, not necessarily
Yeah,
going to preservation.
yes.
So Judge Francis, they're all coming to you and saying, we're involved in this litigation. It's a multi-million-dollar litigation. We have a well-heeled corporation involved here. They're pretty good active managers. But, you know, they've got these punch cards that they don't know what to do with, and no one can read anymore, but we think they may be relevant. There may be relevant information on those punch cards. We want to send them to Carnegie Mellon to run the punch cards, you know, at X dollars. What do you think? Where's proportion? Let's go to proportionality. I want to go there anyway. What would you think about that? They don't know what it is, but they think there's something on it.
I think they send a sample. I think that one way to approach proportionality in preservation is to get a handle on the data that you have by sampling. And the punch cards is a great example, because there you have what sounds like homogeneous data. You can take a sample, figure out whether or not it's relevant, and if it's not, throw out the punch cards. If it is, hold on.
Who picks the punch cards to search, and how many? Whose choice is that?
Regards, he's the expert.
I knew you'd get some business there.
Dan?
That's not like much, but it's just a sample.
Dan, let's just say, Lynn's company has 500,000 punch cards. They found them in boxes. But we know at the outside of the box that from a certain time period that Bill is interested in for some reason. 500,000 punch cards, don't know what they're on, doesn't say anything on them other than a box. Punch cards showing antitrust conspiracy. That's what the box says. Something like that. No.
Is this a slip and fall?
Yes. No, seriously. Let's say Judge Francis calls you up, formally or informally, and say, look, I've got 1 million punch cards. We don't know what's on them. Someone thinks they're relevant, someone not. What do you go through? Dan makes his living talking to people about this, by the way. I'm not pushing Dan. I'm just being realistic about what you do. What do you tell them as far as a sample? How do you think about doing a sample of, or let's say you have a terabyte of data, just 200-odd million pages. How do you sample that?
Well, the good news is that sampling can allow us, using audit techniques, to look at a much smaller population than you would normally expect to get a handle on what those documents might contain. We hear sample sizes everywhere from 400 to 3,000 to cover anywhere from a 95% to a 99% confidence level. It's really important, though, how you frame the question you're trying to answer as to how you choose your sample size. But having done that, you can use sampling effectively to test a population to see if it fits your criteria. Does this population of 1 million contain a single punch card or a set of punch cards that reflect upon the issue I'm interested in? And you might find that, in fact, you are comfortable with looking at 400, and if you come back with 0, or even if you come back with a small number, you can then evaluate, I don't believe there are any. I believe that the level is so few that it doesn't warrant the expected expense of going further. I was involved in a mediation where the judge in the mediation actually had one of the parties sample their repository to see if there was residual documents responsive to new search terms. And we tested it, and there were documents. But in that case, the judge made the ruling that there weren't enough to warrant the cost of going back and getting these extra 3,000 documents. My client didn't agree with the ruling, but it was a good ruling at the time because it was a proportionate ruling.
This example is maybe too easy, because punch cards are going to be homogeneous. If this was a million emails or a million assorted documents, some of which are emails, some of which are electronic documents and so forth, it would be much more difficult.
I think it's easy to get for people to get a handle of it. I hate to say it, although we all know everything about electronics now, right? Yeah, we are all computer techs as well as everything else as lawyers. It's easy for people to visualize something in their hands sometimes, even though it's difficult to do in the real world.
I have a real world example of this because I was asked to help a company that, for obvious reasons I won't name, they had about 100,000 backup tapes. And their question to me was, do we have to sample these backup tapes before we destroy them?
Can I ask you a question before you go on?
Yes.
Where were they in the records retention schedule of this unknown company?
All over the place.
Oh, so there was no...
Like, this was, some of these were 20 years old, some were more.
So they just kept...
Some were less. They, look, there are document warehouses all over this country with uncategorized boxes of paper. So are we really saying that in order to be compliant with our preservation and production obligations, we're going to ask all of the custodians of those millions of uncategorized boxes to go sample them? I don't think so. Sampling in this particular case didn't work because the backup tapes were not homogeneous. They were from all different sources. And I will tell you the advice I gave. The advice was exhaust the sources. This was before reading backup tapes was as economical as it is now. I'm not sure my advice would change, even though it's only $5 a tape now, but back then it was a much higher number. My advice was, if you can't tell, having exhausted all sources of information outside the tape, witnesses, records, file custodians, what have you, that there is something relevant on the tapes, then I think you're free to discard them. And Bill is going to say, no, that was a horrible tragedy. but you know what? My practical advice was to the client, how's Bill going to prove there was anything if by exhausting all...
In your scenario, was there a threat of litigation or an act of litigation?
This was simple management of the ESI. They wanted to manage their information sources, and they had these 100,000 backup tapes of a variety of sources. Now, they had ongoing litigation. This was a company with thousands of cases. So it's conceivable that on one of those tapes, there was something that Bill would say was super relevant. But
if they had no outstanding litigation and there was otherwise no, record retention requirement, you would have, I'm assuming, told them, go ahead and get rid of it.
yeah, well, that's an easy case. That's an easy case.
Yeah, the case where I thought you were going, and back to Lynn's point earlier, it's really important to have an active retention schedule and to follow it. And to not hold on to everything. What bothers me is that these records were kept for years after they were no longer needed by the company. And all of a sudden now that, I thought this was a myth, all of a sudden now that there's litigation, they don't want to keep them anymore. Well, wait a minute. If you hold on to records and you don't destroy them when they're no longer useful and needed for either business reasons or litigation purposes, then why should you have the right then, after you're in a litigation environment, all of a sudden to be concerned about that and to start throwing those things out?
But you're suggesting that there's never a look back, because there's always going to be litigation. So there's never going to be a point in time where the entity
It's free.
is free to destroy that which had previously.
But you two are talking about the burden of proof. Who's got to show that there's nothing on there? Your position is, we looked extrinsically.
Yes.
We didn't find anything we can get rid of. Bill's, I think, would be more, well, you know, maybe there's something on there, maybe there's not, but you have to make some more affirmative steps, or show me something before I will let you get rid of it.
Well, my point is, if you were so all-fired concerned about getting rid of these records, why didn't you do so a long time ago? Why did you wait until a lawsuit?
Hey, Bill, do you have a perfectly organized attic?
Yes, I do. My basement, on the other hand, but the point, look, there's no perfection here, but the point is that it's vital to have good records management policies and follow, because you can get into a lot of trouble and you can cost yourself money in doing those sorts of exercises later if you don't.
Well, what I'm hearing about preservation generally, at least from you folks, Lynn, you will do things internally up to a certain point. At a certain point, you will call Bob and say, Bob, I need some assistance with something. Then Bob comes in, and Bob's attitude, or the way he likes to work, is to say, yes, I will come in, but I want to engage your people, who are records managers or IT people, whatever, have a team effort to try to get something done, so we preserve what we need to preserve. And at some point, you and Bill will have a conversation to try to whittle down what we can keep separate. Assuming you have a records policy, and the records policy is monitored and enforced. Because we've all seen a lot of instances where you've got a nice policy, nobody ever follows it. Judge, let's talk about Pippin's for a minute. Anybody read the Pippin's decision from the Southern District of New York? Actually, there are two of them. The first one drove people crazy because, although the magistrate judge did not say this, the suggestion was, he said, there's no room for proportionality in the decision to preserve. And then it went up to the district judge. The district judge affirms the magistrate judge and says, well, of course he talked about proportionality. We engage in proportionality when Lynn and Bob make a decision to keep stuff that's discoverable under Rule 26B1, more or less. Is that about right?
That's fair.
Okay, so where does that leave Bob? And where does that leave Bill? Again, when the complaint hasn't been served, and Bob is brought in by Lynn and said, gee, I know I'm going to get sued by that guy Butterfield. I know he's going to file some type of class action because he does one a day. And, well, you know, about. And what can they say in a conversation they have with each other about how do I engage in proportionality when I don't have the complaint?
Well, it leaves them in a conundrum, there's no question about that. And Bob alluded to this earlier, in the pre-litigation phase, you don't have the court to resort to mediate these issues and potentially have a ruling on preservation. And in the best of all possible worlds, it seems to me, you would have a mechanism for getting to a court in order to get that assistance. Frankly, among my colleagues, I haven't seen a lot of traction in favor of such a reform. So I think we're left sort of doing the best we can. So the question really is, looking backward, how is a court going to judge an entity's attempts at proportional preservation? Is the court going to say, oh my God, there's a likelihood that some relevant evidence was lost, you are now subject to spoliation sanctions? Or is the court going to say, well, in good faith, you took these steps, and I think that that's enough to protect you from any spoliation arguments? And I can't predict what all of my colleagues would do. I think that Judge McMahon's general perspective that proportionality applies to preservation would be adopted by the majority of my colleagues. But I don't know what that's going to mean in any particular case. That is the judge going to find that these efforts or these decisions as to proportionality were sufficient? Or is the judge going to get upset and say, look, I'm a judge. My responsibility is to do justice. I can't do justice if relevant information is destroyed before it even gets to me in court, right? That's going to be a judicial perspective among many judges. So it's going to be hard for the entity to think about how you would go about a proportional preservation. We've talked about some of the elements. I mean, one of them is getting rid of duplicate materials. I don't think that's going to irk judges. Another is the sampling issue, which I think is a closer question. Some judges are going to find that to be acceptable, and it's going to depend a lot on the scrutiny that the judge gives to the way the sampling was done and all of that.
So we've got to run the spectrum. We're going to have real bad actors, and when they get rid of things, that's bad. And we have people who, in the normal course of business, just enforce a record schedule, even though there's a litigation hold.
That's right.
And get rid of things.
That's right. I mean, another thing to think about is sort of to what level of granularity do you need to keep data? Suppose you have 1 billion invoices and you have 100 summary reports that captured all of the information that was in those invoices. Can you, pre-litigation, get rid of all the invoices even though it is going to be the subject matter of anticipated litigation? I would argue that you could, but I can imagine that there's some judges that would say no, that would be spoliation.
Someone would be concerned about the detail of getting all the billion of them.
And the question is that detail ultimately going to be over?
Bob, you're going to make these decisions with Lynn. She's bringing you in to help. And so you're going to document them, because obviously from what Judge Francis is saying, you need to be able to prove the reasoning, right?
Yes.
Okay, so you're going in front of Judge Francis, and the other side wants to see your notes, and you say, wait a minute, I can't give that to you. Why anticipate a litigation? That's work product. Can you say that or not? What would you think? Is there an argument to be made that it's subject to privilege or work product somehow? And maybe the judge needs to see it ex parte, and then Bill's going
My
to say,
notes
hey, wait a
of my
minute.
conversations with her,
Yeah.
I think that's privileged. I think it's work product. It's discovery on discovery. There's a whole hell of a lot of things wrong with it.
Understand that, but she didn't keep notes. She depended on you to keep the notes of how reasonable she was.
So, but your hypo doesn't have a crucial fact, now I'll ask you this and you'll give me an affirmative answer. Is there evidence that something has been lost and now you're putting us, Judge Francis is putting us in the position of proving that we took reasonable steps?
Yes, of course. If you kept everything, I wouldn't ask you the question. Because you're not going to over-preserve, because you've already advised her, make sure you follow that record retention schedule. Don't keep notes of lunches unless someone gets food poisoning at one, of course. And then get rid of everything. But now Bill says, hey, wait a minute, you got rid of this stuff.
Well, here's what
It's
I do.
relevant. Okay.
I advise clients when we're in this situation, we're in the moment of making a decision as to whether to let it go or to preserve it. Imagine we're in front of a judge, and not a reasonable judge like Judge Francis, but
Really?
one of the
Okay.
colleagues that
Ronald
he's
Hedges.
Yeah, wait.
Well, not that bad.
But it's 2 years from now, a couple of people involved in the process have left. How do we prove to this judge 2 years later that those decisions we made in the moment today were reasonable? Because that's the standard.
Right.
Yes, you do, but I don't document it. Lynn's records manager documents it for me. Lynn's HR manager, a non-legal witness documents it. And they put it in, in fact, in the backup tape project, we had a proof kit that we put together with sworn statements and a lot of questionnaires answered and so forth. And it's never been tested, but the design of it was to walk into court and show even an unreasonable judge that we have done a reasonable job.
Isn't that still work product?
It could be, but it's not privileged. And,
Right.
so it's a selective disclosure of work product to meet the moment.
Yeah.
The question is when it is at issue, and you want to put it at issue in order to defend your process, right? I mean,
Sure.
at that point, the work product is no longer.
It's relevant. The privilege would be overridden anyway. even against my wishes, but in the right case, I would want to show it to you.
So, wait, just out of curiosity, how many people know what Rule 502 is? Put your hands up. Well, this is a great audience. Usually 1 out of 10 hands go up. I'm serious. So we're really talking about Rule 502 that we're not going to talk about today. About intentional disclosures, if there is a disclosure, if it hasn't been waived or the like.
So that's a different type of 502 though.
Yes.
502 of intending to disclose limited work product versus 502 protecting inadvertent disclosure of documents in a massive production.
Absolutely.
Completely different.
Sure.
But let me make this
Let's
point.
spend the next 30 minutes talking.
Can I make a point before the question? I just
Yeah.
want to, so you're having these discussions pre-lawsuit, right? And you're making these proportionality decisions pre-lawsuit.
But in anticipation of litigation.
In anticipation of litigation. But I guess my point is that the missing link here is when that lawsuit is filed, the first thing you ought to do is pick up the phone and call the other side and say, look, we think we don't need to preserve certain types of information. We want to talk to you about that. We think it's not proportional to preserve that type of information. So rather than being out there all by yourselves, you have an opportunity to get the other side involved. You have the opportunity to get them stipulated.
Yeah, but this may be 2 years after they started anticipating
It may be.
litigation because it took you so long to get your act together and
It
file
may
each
be.
one.
It may be.
Bill's complaints are filed the night after he thinks them. Okay, Dan.
The challenge I have is, I think we're still dealing with yesterday's paradigm, because the world is changing as we live in it. And we're still grappling with the perception that it might somehow be physically and economically possible to save all of the relevant data for a given case. And in some of the companies I'm working with, that is not possible. It is impossible to save all of the potentially, arguably relevant information. It's just too much of it. And if you don't believe it today, wait a few years when you have all of the location information on every object in your entire company tracked on a minute-by-minute basis. And when everyone says things and you have constant video surveillance, you just can't save everything. So it's either today or soon we get to the point where we can only save some, and we have to make proportionality decisions.
And they have to be documented.
Well,
Right.
yes. And so the question is, what can litigants today do, or do you have to wait till we're in the future to start making these unilateral decisions? There are too many counterparties for me to negotiate with each one of them, or it's too early in litigation to negotiate with anybody. How can I find a set of guidelines to allow me to say, these are the 5 steps I need to take to determine proportionality and good faith? Do I need to sample? Do I need to pick my top 30 custodians, or top 50, or top 5? How does the panel suggest, in real advice, how can a party make ex parte or unilateral decisions on proportionality?
The reason this is an issue for all of you, if you're potential litigants, is you can't get into court before a complaint is filed. A city tried to do that in Texas a few years ago under the Declaratory Judgment Act to get a declaration from a federal judge that they did not need to preserve, and they needed to preserve X, and it was thrown out for no case of controversy.
Yeah.
And so you're stuck. But I can't imagine many federal judges are going to want to see a statute that says, by the way, if you guys have a preservation problem pre-litigation, we will let you file a DJ action. Just like their judges don't often get all the rules allowed pre-26F discovery. And there are things that just aren't done. And I can imagine what would happen if you have companies issues the way that Bob's talking about, how often they would love to be able to get into a federal court just to get a ruling on what they keep or don't keep.
No, I think it's a real problem. We have a mutual friend who defends employment disputes. And for his types of cases, he's got a tough road. I mean, because he's got, well, yeah, he's got people suing on an employment decision where the amount of money at stake is relatively low, but the preservation impact could be huge. And I guess one thing I'll throw out there is that if that company had a standard procedure that they follow, when we have this type of employment or threatened employment action, we preserve the following types of records, and here's why. And perhaps that's been the subject of litigation in the past, where there's actually been a controversy they've had to litigate it, but at least a well thought out policy of what's preserved, why it's preserved, what's not preserved, and why it's not proportional to preserve that information. Perhaps of our 1,000 cases like this, we've only used that type of information once, or it's marginally, that type of information is marginally relevant to these types of disputes. But some thought ahead of time as to what the decisions are and why they're being made, and to the extent that they have common types of litigation, a protocol to follow so that they're not making these ad hoc decisions.
The only thing I've seen that actually is a pretty comprehensive list about ESI that's publicly available, I'm sure you all have your own to use with clients or whatever, is actually the last page of the JETWIC protocols on criminal discovery. There's a whole page there listing about data sources and this and that, and conversations.
I mean, the one that just came out. But
Well, it came out in February. It's sent by a group, an organization called JETWG, J-E-T-W-G. It's created by the Attorney General's Office and the Federal Defender's Office, and there are a set of protocols and recommendations for criminal discovery, but they have a great checklist. It's interesting. There may be something to get you started, at least when you're making decisions.
And that may be, you know, this may be totally unreasonable. I'd be interested to hear your thoughts about whether or not that kind of a protocol might be working.
Well, we talked about it at the Denver meeting, a couple of us, about trying to put something together, but would that make sense? Or you like to have your own secret checklist?
I wish I had secret checklists. That sounds really great.
What about the idea of having an organization, suppose somebody founded an organization and said, if you can't find a counterparty to talk to, come talk to us. And we'll come in and try to take a neutral position on helping you make good faith and proportionate decisions. Does that have any weight?
And what, when you say does it have any weight, you're suggesting that this organization places its imprimatur on whatever the preservation decision is, and then, what, act as an expert witness when there's a spoliation motion down the line?
Maybe so.
Okay, I could easily see the immediate problem would be, depending who's in it, that organization would be engaged in unauthorized practice law. Actually, there's a DC Bar opinion that came. No, I understand. Well, no, there's a DC Bar opinion that came out about that very topic a little while ago. That's interesting. But let's talk about new standards organizations another day, because we have to get to the last part that's very important. It is a great idea. Next ongoing, and how long is that going to be?
It's an 18-month project.
Okay, and it just started in January? So January it started?
Yeah, maybe a little earlier than that.
Okay.
And could you give the audience the 3 bullet points of how it works or what it accomplishes?
Well, for our purposes, what it does is that it includes basically checklists for the parties in the court to deal with respect to electronic discovery, including discussions of preservation obligations.
So it's an expansion of what parties are required to do, at least to some degree, for 26F anyway.
That's right. Okay.
There are a lot of things going on around that to experiment with preservation, proportionality, and the like. Another one that comes to mind is the Seventh Circuit, which is the second phase. That's more than anything else the Northern District of Illinois that is working on that. And they're attempting to do the same thing that the Southern District is doing now, and that's come up eventually with checklists, create some type of positions or whatever for people that might be able to assist in disputes and the like. We see a lot of that, but obviously the golden ball here is changing the federal rules of civil procedure. And Bob, I know you're an advocate of it. I understand that. What do you think may be happening, or where do you think we're going in the rule amendment process? And just for the audience, nothing's been formally proposed yet. When it's proposed, it'll probably be a 3-year process, just realistically. So we're talking about nothing happening until when, 2016, 2015?
Something like that.
Okay.
It's years off. There won't even be a draft presented to the Rules Committee until this November. I just heard Judge Campbell speak in Washington a week ago Friday, and he went through a number of very specific changes that are under consideration on every topic other than preservation. And Bill is on the Sedona conference. He's actually on a Sedona team that's working on it. I'm affiliated with Sedona. I don't know where we're going on preservation in terms of rule change. I don't think there's consensus. I think that the plaintiffs on one end of the continuum and the defendants on the other have very differing views. And because rulemaking is a consensus-driven process, I don't see anything definitive or bell-ringing coming out of the Rules Committee on preservation.
The other interesting thing that's happening is the debate about whether the rules are even addressed. It may be so. It's not
Pre-litigation, you mean?
Yeah, if it's not procedural, it's got to be, it's something that's got to be passed affirmatively by Congress, which is not the rulemaking process.
Well, that's true, and I've never considered, in thinking about solutions, I've never lived within the rules enabling act cabin because I think it's a bigger problem than that. Although it does raise the question in my mind, if pre-litigation the courts have no jurisdiction, how does Rule 27 get away with permitting pre-litigation depositions?
Or how does Rule 11 deal with the
Pre-litigation.
reasonable steps that you took prior time?
Right.
Well,
So-
you know the real, are we being recorded today?
We are, forget it, I will tell you.
Too late.
Ask the question in camera.
You know what the real answer to that is? It really depends on the discretion that a judge chooses to exercise under the rules. And one of these days, someone's going to challenge it, and then a court will decide.
Well, the courts justify their exercise of power in this area by invoking their inherent power.
Yes.
And their inherent power is a blank slate on which they can write anything, and that's a problem with the situation now. Not that
Well, wait, now that's not what the Supreme Court said, right? In Chambers, wasn't the Chambers case where they talked about inherent powers?
Or Asbill or something.
Yeah, one of those little Supreme Court decisions.
Okay, fine, but how do I advise clients on what court will do under its inherent power? You know, I can't. Pre-litigation, I have no remedy. I have, as I said before, I have no judge to go to. I have no adversary to talk to. I don't even have a complaint to look at.
And you can't use the Declaratory Judgment Act.
And I can't use debt relief, and Rule 27 doesn't permit it at present. So that's why I think there ought to be a change. I don't think that there is a silver bullet here. I don't think that the proposal I made to the committee last fall is a silver bullet, but it's something. And my fear is that we're gradually building to a point of huge crisis, and if we don't do something to pull back, there will be a moment of collapse.
But Dan seems to think that there's a technological solution and people put everything in some central location, maybe do the auto classification.
No, that is not exactly what I said.
Oh, I'm sorry, I thought you said
What
that.
I said is, we might need to reevaluate the fleeting nature of data as we become more connected, as to whether or not there is such a affirmative need to preserve data, if in fact there are multiple copies of an organization. And that this idea that you have to run out and physically gather everything might not be as large of an impetus today as it was yesterday. Combined with, if we have so much data that's potentially responsive, and we know on the outset we cannot preserve it all, then we have to take proportionality footing from day one. And how do we do that? Is it document-centric? Is it person-centric? Is it system-centric? I think we have to make those decisions. And there are no guidelines right now, and that would be something Sedona could put forth, for parties to make single-party decisions to evaluate proportionality, good faith, and reasonableness in a way that we can report it to be useful in court later. Parties would benefit from those guidelines.
Do I get to talk?
Yeah, 1 second. I don't want to cut Dan off since I rephrased what he just said a minute ago or so.
My response to that issue is clear.
Okay. Bill, well, before we do this, let me just, for the audience, one of your suggestions, Bob, and maybe I'm wrong, was no duty to preserve attaches until there's actual service of process. Is that right?
And no bad faith.
And no bad faith.
Coupled with
Right.
an enveloping, you can't spoliate intentionally.
But you don't spoliate because you don't have a duty to preserve. How can you spoliate?
No, okay, so forget the term spoliate.
Oh, okay.
Don't intentionally destroy the material with the intent of depriving it to an adversarial litigation, even an ephemeral potential adversarial litigation. If you have that enveloping rule, which I think we have for all practical purposes, I think as a society and as a system we could live with commencement as the trigger for affirmative preservation steps.
Bill, we have 5 minutes left. I don't see questions. You have, we started 5 minutes late, so we're going a little, 5 minutes.
For once, Bob and I agree on something. I think Bob's right. I don't think anything is going to come out of the rules committee for quite some time. I was in Dallas with Bob. I've been at the rules committee meeting last November as well as the meeting in March.
And a congressional witness.
I happened to testify in Congress.
Yeah.
But
In front of how many people?
not too many Republicans.
Okay.
Only one member of the majority showed up.
The room was packed.
But anyway, there is a lot of debate going on among members of the committee, and they're frankly struggling. And we've looked at it from Sedona, and we're trying to give them some advice. And frankly, we're struggling, and we're having some of the same struggles that the committee members had. So you said you won't see a proposal until November. I predict you won't see a proposal until March.
On preservation.
On preservation, if ever. Yeah, there are so many. There are rules enabling act problems. There are eerie problems. And then there are all of the problems associated with trying to design something that works and works fairly.
I didn't ask, how many folks are attorneys? Everybody a lawyer? Anybody not an attorney other than, oh, okay. Records people? Records persons, something like that. Yeah, okay. Records person, okay, all right. Anyway, go ahead. Okay.
So the other point I want to make is that I don't deny that there are serious issues that everyone's dealing with respect to preservation. I don't deny that preservation is incredibly expensive. It's interesting, however, that no one has yet determined the cost of preservation. RAND has tried to do it twice. RAND came out with its newest study about a month ago, and it dropped the issue again. So it's too hard to figure out. There's a professor from the University of Chicago, Steve Hubbard, who's been trying to study it. He is probably working on it now, but he's in the sort of early stages of his review. So it's difficult to put a handle on the actual cost of preservation other than just stories that are told by members of the bar. But the other thing that's been mentioned a lot by Bob and his colleagues are that they're so afraid and they're over-preserving because these sanctions decisions are all over the place. Well, I want to talk about a federal judicial conference study that was done recently, and FJC studied sanctions motions in 9 federal districts. What they concluded was that motions for sanctions were sought in 1/15 of 1% of cases in those 9 districts. Gibson Dunn studied the percentage of sanctions decisions that were successful. Okay, so motion brought, sanction rendered. Successful in about 50% of the time. So 1/15 of 1% of the cases brought, and even there, those motions are successful 50% of the time.
But Bob will tell you it's the interorum effect of maybe being on the receiving end.
Can I say one more thing before Bob?
One more
answers
thing,
that?
then we got to let you
One more thing. The other thing is if you look at the sanctions jurisprudence, There are a couple of exceptions, but other than those exceptions, one happens to be in this federal district court. But except for those cases, by and large, the serious sanctions are not being given for negligent conduct. They're being given for very egregious conduct that we would all agree merit sanctions.
Like the 2 employees who stood on top of a garage, parking garage, and threw the tapes
That
down?
might be one of the
Okay.
cases, yeah.
By and large is the key qualifier, because I'm not in the business of rolling the dice for my clients that pay me a lot of money, and Lynn doesn't hire me to do that. So as things stand now, I have to protect against, the worst case, because there is no rule baseline against which I can measure their preservation efforts. But, your data, I think, shows not that it's unreasonable to fear sanctions, because if you get hit by a sanction, your career is over and your company's brand is sullied. Just as if your house burns down, you don't have a house, even though there's only a 1% chance, you still buy insurance. But I think the data proves that this whole affirmative preservation regime is a solution in search of a problem. I don't think that, we see the poster child cases, but I've worked inside the privilege for 38 years with American companies, and I don't see people with the heads or the hearts that would deliberately destroy data when they were told not to, that would engage in these shredding parties or what have you.
Other than Rambus?
Other than Rambus, yes. Obviously, you've got your poster child case. I've got the rest of America.
And that's a fitting end. Other than to note, we have had an instance in the last month of someone in Louisiana being indicted for deleting information off a cell phone. Now, that's different. That's obstruction of justice.
Right.
But interesting issue. We're seeing more and more electronic issues obviously coming up in criminal cases, which takes all this to the constitutional dimension. It's a lot different. Judge, you're the judge. Last comment. You get the last word. Other than one of our hosts here.
Let me follow up on the last discussion. I agree that it is unlikely that we'll see anything soon, and probably see anything at all dealing with preservation. It is much more likely that we will see the committee addressing it from the back end, that is, or the front end, however you want to look at it, that is by amending the rules to deal with spoliation, which I think, with sanctions, which I think is a mistake. I think it's a mistake to take away judicial discretion with respect to the penalties that are imposed for spoliation, rather than deal with what is admittedly the harder problem, which is defining the obligation to be given. So I'm pessimistic about where the committee is ultimately going.
You were sitting there quietly listening to our two friends there, had a spirited debate. It was not a dialogue.
The only comment I have is
Never.
something that I started with at the beginning. From my perspective, at where I sit now, I'm still going to be conservative, because I think there's a lot that's unsettled.
No matter what happens, you're
And
going to be conservative.
to me, as Bob has mentioned, the risk to me as an in-house lawyer is as great as it is for the outside counsel that advise us. And I don't want to be on the end of a sanctioned motion either.
There was a decision out of the Northern District of Illinois where a client and attorney were both sanctioned by a magistrate judge. It went up to the district judge, and the district judge reversed the sanction on the lawyer because he said the lawyer did everything he could do. He told them to implement a hold, told them how to do it, but once that was done, that was really about what he had to do, and he asked if they were doing it. So it wasn't as if he wasn't monitoring everything. So there's always that point of a possible contention inside and out, but Bob would solve that because Bob's going to have a team with you guys with him all the time. So he'll be intimately involved in everything that happens, right? Thank you all very much for coming. Do you have a goodbye statement you want to make?
Just to make sure that you, if you CLE credit, get signed in, we'll be following up. We've received a lot of materials from our panelists, over 1,200 pages of stuff. We chose not to print. We gave a subset of that in a handout, but all that will will be posted. We'll send you a quick note just so you can access that information as a follow-up to that. Chris, anything else? Thank you all for attending, and thank you all.